Good morning, everybody. Welcome to an oral argument session on the 5th District Court of Appeal. Please be mindful this is being streamed live on YouTube and also being recorded. I'd like to introduce the panel this morning. My name is Dan Traver. I'm from Orange County. I'm joined by my colleague, Judge Jake Cohen from Orange County. And the third member of the panel is an associate judge, Joe Boatwright, who is from Putnam County. This is case number 20-378, Larry J. Morelli Jr. versus the Hernando County Sheriff's Office. Each side will have 20 minutes to present their arguments. We would assume that Mr. Morelli would want to reserve 5 minutes for rebuttal, unless, Ms. Toomey, you tell me differently. And you may proceed.
Yes, Your Honor. Good morning. May it please the court, and I would take that standard 5-minute reservation time for rebuttal. My name is Deborah Toomey, and I represent the appellant Larry Morelli Jr. Mr. Morelli is appealing the entry of a trial court's final order denying his motion to vacate the entry of a risk protection order that was entered pursuant to the Florida Rules of Civil Procedure 1.540B. I think what first needs to be addressed before this court is the standard of review. As the Sheriff's Office has taken a different position, it's Mr. Morelli's position that the proper standard of review for this court is de novo. Mr. Morelli requests that the legal sufficiency of the proceedings below be reviewed de novo. It's the procedural due process. There's no factual distinction involved. And for that end, Mr. Morelli requests that this court use the de novo standard of review. Which brings us to the crux of this appeal, and that is whether or not the lower court afforded Mr. Morelli the requisite constitutional procedural due process rights in its entry of the final risk protection order. Constitutional procedural due process serves as a vehicle to ensure fair treatment of all individuals through the proper administration of justice. And while there is no gold standard, if you will, and the specific parameters of fair notice and a meaningful opportunity to be heard are not fixed, the courts have routinely looked to 3 factors to determine whether the process that was used is constitutionally sound. And those 3 factors are, first, the interest that's involved. Here we have one.
Ms. Toomey, didn't your client consent to the removal of the weapons?
Mr. Morelli consented. Well, that's kind of a loaded question, but ultimately at the end, I know that's the Sheriff's Office position that Mr. Morelli consented to the risk protection order, but ultimately Mr. Morelli consented to the limited forfeiture of the firearms or the firearm that was already in the Sheriff's Office possession at the time of the hearing. Nothing more and nothing less. It was a limited forfeiture.
Ms. Toomey, you mentioned, I guess that you're on the motion to vacate. It's on the record on page 169. The judge asked you if you're contesting the prospective ability of Mr. Morelli to go out and get firearms, and you say, no, Judge, we're contesting the fact that he wasn't provided with the procedural due process of a final hearing. So is that different than what you're saying here today?
I think it's really the same thing. The fact that this order was entered in violation of the procedural due process is the crux of this entire proceeding. The fact that at the time of the hearing, Mr. Morelli had been served with an ex parte temporary petition for emergency relief, which is a lower burden, which only requires the lower court to find reasonable cause for the entry of an order. That's what Mr. Morelli was served with. He was served with a notice of hearing. He appeared for that hearing. There was a discussion amongst him and the court, Mr. Morelli and the court. And the only thing during that 6-minute hearing, the only thing that was agreed to, if you will, was the fact that the Sheriff's Office would be allowed to keep, to safeguard, to really hold in forfeiture the firearm that it had in its possession. When Mr. Morelli left that hearing, and it was a 6-minute hearing, when Mr. Morelli left that hearing, that was the only thing he was on notice of. And the relief that was requested by the sheriff's office was temporary emergency relief, temporary.
So let me see if I understand your position. Your client has, some sort of episode sufficient enough for the sheriff's office to seize his firearms under a risk protection order, but your position is that it would be fine for him then to go out and purchase any number of different weapons, and that's no problem at all, right?
I humbly, I don't believe that that is truly the issue before the court. If the sheriff's office truly thought that Mr. Morelli was such a danger to himself and to the community of the state of Florida and the community of Hernando County, then the procedures in the risk protection statute, i.e. a mental health evaluation, psychological evaluation, something of more substance than, okay, let's just enter this final risk protection order and call it a day. So really, to that end, that cuts against the sheriff's office in that they never sought those additional measures that ultimately this risk protection order was put in place for. We know that it was based on.
If the trial judge had entered a requirement that your client obtain a mental health evaluation at that hearing, would it have violated his due process rights?
No, because in the ex parte risk protection order, that's one of the issues that the lower court must consider in even the entry of an ex parte. So I guess my basis or my argument is that the sheriff's office, if they were so concerned, would have after, or at least at that hearing, if they were so concerned for the safety of Mr. Morelli and collectively the citizens of Hernando County, surely that should have been addressed. I mean, that's the reason why we have the statute, right? Is for mental.
So anything, if I understand your argument, anything that is contained as relief sought in the petition is not going to be a due process violation.
In the ex parte or the final?
Well, I understand your argument on the ex parte versus final. I'm asking you about the ex parte.
No, because he was served notice with that. So he was served notice with that temporary relief that the sheriff's office requested. So temporarily he was divested of that ability. So he goes to this hearing and he's led on this path of, well, you're only going to be giving up the firearms or forfeiting the firearms that the sheriff's office has. And even at one point during the hearing, Mr. Morelli indicates that he wants a hearing, and then the court, indicates to him or tells him, well, why do we need to have a hearing? If you agree that the sheriff's office can hold these things for the time being or for the balance of the year, then, really what's the big deal? And I understand that. I mean, there's clearly different burdens here. You
can waive your due process rights, correct?
Correct. You can waive any constitutional right. I do not disagree with that. Yes.
Is your issue then the thoroughness of the trial court's colloquy?
It's the thoroughness, in addition to the fact that after Mr. Morelli leaves that hearing, he's then served with a petition, a different pleading, which is requesting even greater relief than originally sought by the sheriff's office. So these risk protection proceedings are garnered by or are ruled by the civil rules of procedure. And when you file something with the court, that pleading has to put the relief in there that you're seeking. So at that point in time, Mr. Morelli is only on notice of the temporary ex parte emergency relief, but then he leaves the hearing and he's served the following day with a new pleading seeking a 1-year risk protection order and asking the sheriff's office, asking for another hearing date to be set with 14 days. So it's extremely confusing procedurally how this was done. The petitions and the orders that were used in this case, they do not follow the Florida statute. They don't follow along the administrative orders that took effect in January of 2019. And there's a reason why we have these procedures both in the statute, the Florida Rules of Civil Procedure, and the administrative order. The purpose is to provide notice and provide not a sham hearing, but a meaningful hearing and notice of what you are giving up as an individual. Because Mr. Morelli, as the court knows, was there and he's not entitled to representation. Surely he could have got representation prior to the hearing, but he appeared pro se, appeared by himself. So I think special care needs to be taken when someone appears before the court without a lawyer and you have the sheriff's office lawyer there and then you have the court there as well. So
I mean, it happens literally every single day. It's happening right now in domestic violence court, correct?
Yes, and I know Your Honor is extremely involved with the domestic violence procedures and whatnot, and I understand that. Yes, I absolutely.
Is there, just unpacking your previous answer, if the argument is that the bifurcated process, which I understand is no longer in effect in Hernando County, is what deprived him of his due process rights, would there ever have been a colloquy that would have been sufficient to obtain his consent?
Yes, I think the court should have gone through exactly, or at least not, I don't want to say misled, because I don't think the lower court intentionally misled Mr. Morelli, but I think it should have been clear to him that we're not going to have this hearing. You are giving up you cannot have a gun, you cannot be in possession of a firearm or ammunition. And that's not what was told to Mr. Morelli.
So basically it would be, you can't have any more guns. You can't have your existing guns for a year. You can't buy any new guns, and we're not going to have the final hearing. And that would have been sufficient to protect his due process rights.
I think that the court, and I know there's no gold standard here, but I think the court needed at the very least, and I think there should have been more that goes along with the statute in addressing the mental health issues or any mental health issues, or at least having an evaluation. But to answer the court's question, I think that at the very least that needed to be made absolutely clear to Mr. Morelli, because that is not clear from the transcript of the record in my mind.
So your position is, and it's basically like a quality argument, that a colloquy theoretically could have been good enough, but this one wasn't.
More or less, just like a Ferretta hearing, a colloquy in a Ferretta hearing has to be rather.
So then what deference do we give to what appears to be a factual finding from the trial court that this consent was knowing and voluntary?
I don't think the court needs to give any deference to the lower court's view, the lower court's ruling, in that you can have a factual distinction versus a legal sufficiency. So factually,
But for example, like you would agree with me that there is some way, and there is some way to tell when you're talking to somebody whether or not they're following along, whether they understand, or whether they're just doing it because they feel like they're being coerced to do it. I mean, we obviously can't teleport ourselves into that risk protection hearing and see what that particular trial judge saw. So if that trial judge says, I find factually that this guy understood what I was talking about, that this guy was knowingly and voluntarily consenting, I just don't necessarily know if that doesn't come to us, on a more deferential standard of review than the one that you're suggesting that we employ.
Well, I understand what the court is saying, but I still think it's a legal sufficiency, whether you look at the facts or not. Factually, it's the legal sufficiency as to the quality, if you will, of the waiver the alleged waiver or the agreement or what have you. So it's still a legal, you're still looking at it, or you should still be looking at it anew from a legal perspective. Legally, was this colloquy or this transaction between the court and Mr. Morelli enough? Was it legally sufficient? And that requires a de novo standard of review. In my
I don't understand how an issue of voluntariness isn't factual.
Well, I think the issue of voluntariness can be factual, but then it can also be legal. So there's a factual determination as to whether something's voluntary, and you can see that from the facts in the record here. We have a 6-minute transcript. But then whether or not that meets the legal threshold of voluntariness, knowingly, intelligently, I think that's a different standard, a different view that the court needs to look at the transcript of this hearing, along with the record and the pleadings that were filed by the sheriff's office.
And counsel, you're into your rebuttal time?
I would reserve.
All right. I'm not sure I'm pronouncing this the right way. Mr. Fritton, would you unmute and proceed at your convenience?
Good morning. May it please the court, my name is Joel Fritton. I represent the appellee, and I am counsel for the Hernando County Sheriff's Office and Hernando County Sheriff Al Nienhuis. I think the issues, I think we're probably in agreement on that this issue is about notice and the conduct of the hearing on December 9th. It's our position in this case that Mr. Morelli enjoyed more than adequate due process in the lower court's imposition of this risk protection order and the denial of the 1.540 motion on December 9th. The case is about due process, but we talk about the standard a little earlier, and there is a factual determination that has to be made here, and the judge makes that factual determination on December 9th when he goes back and he looks at the record. And I think it's also important to point out that there was no evidence presented by the appellant here. They stood on the record, and that record indicated that Mr. Morelli was served, that he was present, that he had the benefit of the ability to read that ex parte order before he appeared, which he did, that while the appellant focuses on some of the language that the chief judge used in that hearing, there's also a portion of that colloquy where Judge Merritt specifically says, do you have any other guns? So it's not just about the guns that HSO or the ammunition that HSO, the Hernando County Sheriff's Office, has in their possession on that day pursuant to that order, but it's about all guns. It's putting him on notice that all guns are no longer fair game for him to own, for him to possess, for him to transfer. And he follows that up with a question as to whether he has currently divested himself or anyone else is holding any guns, again, any guns. So he's not specifically just referencing these guns. And the case law, as I'm sure your honors are clear, is abundantly clear itself, and that minor errors or irregularities in the proceedings are not going to void an order. When we look at what occurred here, we have an individual that asked questions, that answered questions, then spoke up when he didn't understand. And then he made a tactical decision at this hearing not to go forward with his February 15th hearing that was set and that was requested in the ex parte order. So the relief of a final order is mentioned and is requested in the ex parte order. He makes that decision because it's logical for him to do so at the time. It made sense. There were criminal charges that stemmed from this written threat that was put out on social media. And at that point in time, it made sense for him not to entangle himself with a Miranda issue or entangle himself with potentially making admissions. The affidavit was abundantly clear as to what the allegations were, and it was not a situation where Mr. Morelli felt like he was going to be able to contest that and argue his way out of it. If you look at the findings of the lower court on December 9th, which the judge appropriately held an evidentiary hearing, he looks back at all these things. He looks back at the record. He looks back at the conduct of Mr. Morelli. He looks back at the fact that this ex parte order was served on him and that the relief from the 15th was specifically requested in the ex parte order. We talked about the bifurcated hearing or request that formally was a part of the Hernando County hearings. It's a bit redundant, and now a temporary petition is filed with a checkbox requesting a final. The petitions on that day mirrored each other. A petition for a temporary is based on the same facts, the same affidavit, the same circumstances that the petition for the final hearing is based on.
Mr. Britton, when the judge was looking back over the case, Mr. Morelli had been Baker acted on February 4th, correct?
That's correct.
The hearing went forth on February the 8th?
Yes, Your Honor.
Okay. Was this brought to the trial court's attention? Was there any issue about the mental state of Mr. Morelli when he consented based on the prior Baker Act?
There was no issue. There was, and of course, mental competency and a Baker Act are two different issues. But Mr. Morelli had been released from the Baker Act facility. He appeared of his own volition. He wasn't brought by any government authority. He didn't appear via video from the hospital. He'd been released, I believe the record indicates, a day later. So the mental capacity or the mental issue was not brought up. However, I think it's important to look at when reviewing the mental issue, his ability to answer questions, his appearance in the courtroom. That's noted in the December 9th order. The judge makes factual findings related to that. He talks about the fact that he's responsive, that he's conducting himself appropriately. So I think the mental issue is sort of an afterthought. There's a conversation that occurs on the record about this day and age, you simply can't make those statements. And there was no irrational response to that statement or any other statement by Mr. Morelli. Going to the issue of waiver, a waiver obviously has to be knowing and voluntary. We point back to those instances in the record where the judge refers to any and all guns. We look at the language of the temporary order to establish that this was a knowing and voluntary waiver. He didn't want to go forward. And I think it's important to note his interests were in play here until they weren't. This isn't appealed 30 days later. This comes back several months later after his position has changed, after he's been arrested for a violation of this and other law violations. I think that's relevant to show that this is a bit self-serving at this point, whereas at the point in time when he stipulated, it was self-serving then too. It's what a reasonable person would do. But a reasonable person wouldn't interpret the risk protection petition and order that was served on him or the conversations with the judge to only restrict his ability to possess that gun that was located with him that day in the search warrant. It's just not a reasonable position and would render the risk protection order entirely useless statewide. And I don't think that was the intent of the legislature either. In our petition, we talk about the harmless error standard and how it applies to due process violations, and the cases indicate that. As you know, it's statutory and both based on case law here, and as to whether there's any impact at all on the most important portion here, which would be his stipulation. And one petition versus two petitions that say the same thing, there's no impact here because nothing changed from the first to the second. As to the court's language, he indicates in his colloquy with Mr. Morelli that they're focusing on any guns and all ammunition, and that was the understanding that the judge had and the understanding that Mr. Morelli had. So if there is any error here in the language of the judge and the imperfection of any colloquy, it is a harmless error. Due process doesn't require perfection. It's intensely fact specific, and in this set of facts, due process is present, it was protected, and it was adequate. As to the returning to the issue of the mental capacity, there was an indication made in the pleadings about the judge not making a finding or ordering rather that he attend some type of substance abuse or mental health counseling or so on. There's nothing in the statute that requires the judge to order anything. It is a consideration, but there's absolutely nothing in 790.401 that requires a judge to take any action based on that. And I think that's abundantly clear and critical. what we have here in the form of this appeal or this motion is it's an attempt at a second bite at the apple. We wouldn't allow in a criminal case an individual to plea and then later complain of not receiving a trial. In fact, that's what's happening here. Mr. Morelli did stipulate, he did agree that it was in his best interest at the time and for a period of months to not challenge this and to it'd be better off to abide by it and focus on the other issues that are directly related to it until it no longer benefited him and until it no longer made sense. I think the court has every right and should review this as an abuse of discretion. As far as the factual findings in the December 9th order, the judge does an exceedingly well job at spelling out his findings and what he's observed and what he's seen from what was presented, and there was no additional evidence. So in close, the Sheriff's Office would ask that you affirm this order denying the motion to vacate and ultimately uphold this risk protection order. Thank you.
Ms. Toomey, rebuttal. Please unmute. Thank you.
Yes, Your Honor. Just a few things I'd like to correct for the record. The ex parte petition is not mirror the petition in that the ex parte petition specifically asks for temporary relief. The second petition that was filed after Mr. Morelli, later on that afternoon, after Mr. Morelli had that 6-minute hearing and then served upon him the very next day, specifically asks for a final risk protection order to be entered. So they do not mirror one another for the relief. And the Sheriff's Office is limited to the relief that is pled in their pleading. And that's what Mr. Morelli needs to be or needed to be on notice of. Secondly, with regards to Mr. Morelli's mental issues and mental status at the time, Mr. Morelli was Baker acted on February 4th of 2019 at about 5 o'clock in the afternoon. Mr. Morelli was then arrested and taken from the Baker Act facility that same evening at about 1 o'clock in the afternoon, arrested and transported to the Sheriff's Office. He had received no medical or mental health evaluation from the Baker Act facility. The Sheriff's Office goes and picks him up from the facility and brings him to the jail. And then
it looked like that argument was made in the underlying motion, but it didn't look like it was pursued at the hearing, and it didn't look like any evidence was presented to support that. Is that a fair statement?
That is a fair statement. There was no evidence prepared. Yeah, that's correct, Judge.
If, say that the evidence had been presented and the trial court had made a factual finding that he was competent to proceed and give consent at that particular point in time, would we give that finding any deference?
Yes. Yes. Secondly, or finally, I should say, just as the Sheriff's Office is arguing that Mr. Morelli could stipulate, waive, etc., to relief, the Sheriff's Office is equally able to waive, stipulate, and agree to certain relief. And the fact that the Sheriff's Office never proceeded and never went forward on the original petition, filed a second petition, they are equally able to waive, stipulate, agree. And what the Sheriff's Office did was they stipulated and they agreed to this limited forfeiture. Maybe perhaps in hindsight, they realized, well, we made a mistake. We better serve them with this petition. I don't know, but just as, I mean, that's why we have appellate courts, we have the Florida Supreme Court, everyone makes mistakes and errors. But when we're talking about procedural due process rights and one's constitutional interests, I think we have to take special care in making sure that procedure is followed in a meaningful, fair way for individuals. I mean, this risk protection order statute is new, and I understand that it was enacted over the shooting in Broward County, but that does not mean that it doesn't mean that the Sheriff's Office gets to use this as a loophole or just go through these proceedings, you know, really as a pretense and violate due process and abuse really the process of these individuals, because it's so quick, it's so fast, and these individuals are coming in there unrepresented. Mr. Morelli just off of a Baker Act that he never even got full evaluation of. So I think these things are extremely important for the sheriff's office to consider as a petitioner seeking this type of relief, and the lower court to consider. So with that, I would ask that the lower court remand this case and remand it and request or order the lower court to vacate the final risk protection order. Thank you.
Thank you.